Hello everyone, my name is Aria, and today I'll be teaching you about competence to consent to a search or a seizure. In our previous module, we learned about adjudicative competence, which deals with an individual's ability to understand and participate in the legal process and assist in their own defense, as defined under Dusky v. United States. Similar to, but separate from, adjudicative competence is the concept of decisional competence, which deals with an individual's ability to make a particular decision. In the criminal justice system, decisional competence relates to a defendant's ability to make informed decisions involving their own rights throughout various stages of the criminal process. Examples of decisional competencies include the choice to consent to a search and seizure, the choice to enter a plea, and the choice to waive the right to counsel and represent oneself in court. Although often heard in tandem, a search and a seizure are two distinctly different yet interrelated acts carried out by law enforcement. A search is when law enforcement searches an individual's person and/or their property for the purpose of uncovering evidence of a crime, fruits of a crime, or contraband. A seizure can be defined as one of two things: either the act of taking possession of the evidence uncovered during a search, or the act of detaining or arresting an individual. The Fourth Amendment protects against unreasonable searches and seizures carried out by law enforcement. It does this by requiring that searches be carried out under authority of a search warrant that is based on probable cause and signed by a judge. Still, there are several exceptions in which a warrantless search can be conducted without fear of having the fruits of their labor suppressed. A few of those exceptions are evidence found in plain view, searches and seizures made based on exigent circumstances, inventory searches incident to an individual's arrest, administrative searches, and of course, consent searches. So what is a consent search? In Schneckloth v. Bustamante, the Supreme Court of the United States held that a valid consent search is one in which an individual gives law enforcement the consent to search their person and/or property voluntarily and without coercion. However, the Supreme Court also held that consent is still considered voluntary, even if the individual unknowingly waived their right to refuse a search. In the next slide, we will dive a little further into the facts of this case. Just to recap, Schneckloff v. Bustamante requires that consent to search be given both voluntarily and without coercion. When it comes to the Fourth Amendment protections against unreasonable search and seizure, the competency issue comes into play when determining whether or not the individual who consented to a search and seizure was competent to provide that consent. Clinical evaluations on this matter primarily focus on the extent to which the police coerced the individual providing the consent to search. Since there is no requirement for law enforcement to inform individuals of their right to refuse a search, an individual's understanding of their rights in this regard is typically a secondary issue. So, what does the research say about the competency issue when it comes to searches and seizures? There have been a few case studies conducted on the matter. For instance, Kagehiro conducted research on the circumstances in which consent is most likely to be considered voluntary and uncoerced, using simulated search scenarios in which participants were subjected to requests to search in either an interrogative or a declarative fashion. Participants who were subjected to interrogatory requests to search, such as, "Would you mind if I came in and look around?" perceived they had more choice in the matter. These participants were more likely to grant the request for consent and less likely to ask questions about the police objective. Participants who were subjected to declarative requests, such as, "I would appreciate it if I could come in and look around," perceived they had less choice in the matter. These participants were less likely to grant consent and more likely to ask questions about police objectives. Time for a video debrief. In this video, the officer asked the male who was being detained for consent to search his property in an interrogatory fashion. The male stated with his words that he did not mind if the officer searched his belongings, but as the video goes on and the officer moved towards the male's belongings, presumably to conduct a search, the male clearly stated he did not consent to the officer searching his belongings. The individual in this video displayed decisional competence in this encounter, as he remained adamant in his refusal to consent to a search, although his word choice admittedly confused the officer. However, people are not always so confident in their right to refuse. Research on this topic will be discussed in the next slide. This study involved individuals who had actually been confronted by the police and found that individuals consented to searches for one primary reason: fear of retaliation if they refused to consent. A majority of the participants were unaware they had a legal right to refuse to consent to a search, and those who were aware expressed they did not have faith in the ability of the police to abide by the law and respect their right to refuse. Nadler conducted empirical research utilizing a survey of consent-based searches, which revealed that citizens often did not feel free to decline an officer's request to search. Furthermore, citizens developed the belief that any attempts to decline the officer's request to consent would be interpreted by the officer as a refusal to cooperate, which could result in negative consequences. The research suggests that when an officer asks for consent to search an individual's person and or their property, that individual is faced with an unfortunate dilemma: either agree to a request they would rather decline, or refuse the request and face the potential consequences of not cooperating. You will be utilizing the 3 research studies reviewed in this lesson and the Supreme Court's ruling of Schneckloth v. Bustamante to answer this week's discussion question. Remember, in Schneckloth v. Bustamante, the Supreme Court held that a valid consent search is one in which an individual gives law enforcement the consent to search their person and or property voluntarily and without coercion. However, the Supreme Court also held that individuals do not need to be informed about their right to refuse a consent to search request in order for their consent to be considered valid. What does the research suggest regarding an individual's competency to consent, and what should the standard for competency be based on the research discussed in this lesson? These are the references I used when creating this presentation. I hope you enjoyed learning about the competency to consent to a search and seizure, and thank you for sticking with me.